Hello, this is Matt on the Moon Lambo channel. Are the judges in over their heads in the SEC v. Ripple case and the SEC v. LBRY case? Now, I say this considering that regarding a hearing in the LBRY case, which occurred in July of this year, just a few months back, the transcript has now been made public. And I went ahead and picked through it, and I looked at what LBRY had to say on social media about this. And I'll tell you this. The judge was perhaps a bit overconfident about how quickly he'd be able to resolve this issue. And additionally, he was acknowledging just months ago certain things that he didn't understand about cryptocurrency and blockchain technology. And at least he's being upfront and attempting to understand, okay, credit where it's due, but acknowledging he didn't understand it. And also noting that there isn't sufficient case law that he's aware of to settle this case. A little alarming, right? So, I mean, who wouldn't be in over their heads to some degree, I guess, if there's not sufficient case law? But even on the the technology side, blockchain and cryptocurrency technology, like if you're just being thrown into this, you may be a very brilliant judge and a very fair judge and reasonable, and you're trying to apply precedent to this case and doing everything in good faith. Even if you're doing that, it is extremely difficult to be thrown into crypto and then come to a highly consequential decision in a matter of like a month or two. So I'm going to share with you some perspective from LBRY on this and my own thoughts along the way. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, shout out and credit to James K. Filan, attorney and member of the XRP community, for sharing this transcription, which was just released literally yesterday. Although, again, the conversation took place, I believe it was July 20th of this year. 84 pages transcribed. And also the official LBRY account shared this on social media as well. And I want to share with you this just to kind of like see how far off we are in terms of, what was expected by this point. Well, here's part of the transcription. And this is the judge speaking here. So mind you, again, this was July 20th. And this judge has said the following. I want to get it done. So he's referencing getting, a conclusion regarding this case. Because they're at summary judgment here. So the judge says, I want to get it done. I'm going to try to get it done expeditiously. I hope by the end of August, but certainly by the end of September, I'll have something and then we can chat, okay? All right, well, it's now the beginning of November, so closer to 3.5 months at this point. Didn't meet your own deadline there. And look, I've said before, I prefer that this judge, if you realize, okay, actually need way more time, I'm fine with that. As long as he does this thing as, precise as, he personally can do. I prefer that rather than something rushed here. Especially considering that, this is going to have some sort of impact in the SEC v. Ripple case, because this thing, it's a virtual certainty that we're going to have a conclusion in the LBRY case before Ripple, and this all matters. So even though it won't be binding precedent, it's going to have an impact on Judge Torres, who gets to make the final determination regarding the SEC v. Ripple case. And as we go through this, I mean, it's not like any judge is going to perfectly understand a brand new technology like this that only a small percentage of humans are actually knowledgeable about. Okay, fine. But I will say, regarding Judge Knepper and Judge Torres in the Ripple lawsuit, it does seem to me that they're also going out of the way to make sure that they understand things and appreciating the complexities, all of the nuances in that case. But either way, I'll say this. I'm cautiously optimistic in the LBRY case. I'm more optimistic in the Ripple case than the LBRY case, partly because after kind of picking through what was stated here, the judge seems to have, in the LBRY case, seems to have less of a clue of what's going on, technologically speaking, and compared to what's going on in the SEC v. Ripple case. Now, again, if he's taking the time to make sure that he really understands this, and it's a major crash course, but he's getting the right understanding and perspective from correct individuals, okay, fine. Maybe it ends up being fine, but I'm just saying, a little bit concerning, just at least to some degree. But yeah, the idea of this being settled by September, I think, is a bit overly optimistic there. And so then you have this thread from LBRY, which reads as follows. The SEC v. LBRY transcript is now public, so we've published it to LBRY. We're rereading it now and will highlight some parts in the replies as we do so. The judge opens with some appreciation to LBRY for not wasting time and for the developed series argument that we presented. A theme we'll see repeatedly from Judge Barbadoro is a belief that this is a complex and nuanced topic. And so it's good to see this. In fact, and this is the reason that I say I'm cautiously optimistic, certainly more optimistic than pessimistic on this, is because if you look at the way that he was going through his line of thinking, in that sense, some of it, the way that they said way more questions for the SEC rather than the defendant, it reminded me of the SEC v. Ripple case. Because the SEC is making a bunch of assertions where things really aren't so clear-cut. And so to me, that seems to be a positive here. But you can look at this portion of the transcript that LBRY shared, which reads as follows. I found quite helpful the fact that LBRY did not choose a scattershot approach to responding to the summary judgment motion. In the SEC's opening brief, they seek summary judgment on the entire claim and lay out why this meets the test for a security under all of its elements, and notes that essentially the other requirements of a failure to register claim are not in dispute. I think, again, LBRY has helpfully and in a focused way presented a developed serious argument that this doesn't meet the definition of a security. Now, look, to me, that's like, whoa, doesn't meet the definition of security. So that already right there, it sounds very positive, which is why I'm more optimistic than not, like I stated here. And it's also good if you look at the middle portion of what was stated here. The SEC's claiming that it's a slam dunk just as a matter of law. That's why you don't need a jury trial. So that's why they're pushing for this motion for summary judgment. But you'll see as we go through this, the judge clearly isn't so confident that this is the case, because he ends up bringing, you'll see like just a moment here, he brings up this idea of investing in a cryptocurrency for an investment purpose versus for consumptive purpose, meaning utility. And so he's recognizing these are different things, and it actually matters for the application of Howey, and that's why there's no case law. So check this out. LBRY then continues and says, early on, the judge also establishes something he repeats a few times, that his job is to fit the facts to establish case law and avoid creating new precedent. The judge views SEC versus SG, a case about a virtual stock exchange, as one of the closest cases. And so, and that's fine. I can appreciate that a judge is seeking to make this important, highly consequential decision in the world of crypto and blockchain based on precedent. The problem is, as the judge acknowledges during this hearing, there is no case law that can guide him in what to do here. You'll see when we get, I can't remember if it's in this one right here. Let's find it. Let me just run through this. So here's what the judge said. And I will just, to let the parties know about my thinking, I am a judge who has a strong theory of precedent. I believe I have to be a faithful lieutenant to the holdings of the Supreme Court and the First Circuit Court of Appeals. I find Judge Selya's decision in the SG case to be the controlling precedent that I have to respect, and I will. Unless someone convinces me that there's something about it that's wrong, I'm going to follow his analytical method and view both parties' arguments through the lens of what I think the SG opinion teaches. Okay, and so that concept, that's what a judge should do. So I'm on board with that. Just adhering to precedent and just trying to apply the law without going outside of the confines. Yes, that's actually what a judge should do. I'm just concerned because, again, as is acknowledged later on, there's not sufficient precedent. LBRY continues. While we've at times mocked the government for its ignorance, Judge Barbadoro, so that's the judge in the LBRY case, Judge Barbadoro was clearly an intelligent man making a good effort to understand the issues. This passage is a good demonstration of that. And I don't feel the need to read this one. If you want to, I'll just go ahead and pause it and you can read it for yourself. But basically, he's questioning the difference between on-chain and off-chain right there. So the point being, he's seeking to understand. Good sign. That's what smart people do. Curious people who are intelligent, they will ask questions and not pretend that they know everything. That's the proper way to go through life, and he seems to be going that way right here. He's not letting ego get out of control. He doesn't seem to have one. And then LBRY says, Judge Barbadoro invents an interesting hypothetical that exposes how hollow the SEC position is. Judge, what if someone invents a coin and promises to never promote it or improve it? Is that still a security? SEC. Yeah, exactly. So take a look at this actual transcript right here. The court, meaning the judge, says the following. So let me ask you, though, let me pursue the opposite extreme case. So I understand you're saying, well, there's plenty of evidence here to suggest that there's an expectation of profit because of LBRY, but what if they're trying to just ride a tulip bulb frenzy case, and they say the way you get into this crypto market is you create a new digital asset and people are buying it up without any prospect of its future performance just because they are. And you get into it and try to sell it on the grounds that, look, we're not going to do anything to develop this product. But once we issue this coin, you can buy it. And like all crypto coins, they're going to go up in value tremendously. So I'll just pause to note right there. He's pointing, to be clear, making up a hypothetical. What if a developer creates a cryptocurrency and upfront says, yeah, we're not going to develop this or do anything additionally with it. It's just here. It's just a thing we made. You guys do whatever you want with it. Which, by the way, if you think in terms of what it means to promote a cryptocurrency, it makes me think of something that Attorney Deaton said in his amicus brief the other day, is in the SEC v. Ripple case, because he pointed out that the SEC has argued that that Ripple is quote unquote promoting the XRP token from the beginning. And XRP's been around since 2012, mind you. So they've been promoting it. And then Attorney Deaton brings up the point, well, okay, but if they've been promoting it, aren't they, like, how could you state that people are relying on that promotion given that Ripple, having been around for the better part of a decade, didn't even have a functioning product utilizing XRP until the last part of 2018. Are people really relying on Ripple for the price of XRP to go up, which is important when you're making these considerations? Or is it more likely the case that people are betting on the entire crypto asset class because they believe there's something to this and it's going to have staying power, and as a result, the entire asset class moves together in terms of price action? Well, of course, it's provably the case that the entire crypto asset class tends to move in tandem, right? And then the judge says, so after laying out that hypothetical, the judge says, that would be okay with you? That would not be a security if you were trying to sell your coin under that theory? We won't do anything, but the market will take care of it, because I think there are a lot of skeptical people about cryptocurrency that suggest that's really why it goes up in value, not because of any good work or bad work that any company does. And the SEC attorney, Mr. Jones here, didn't really know what to say, and I think it may have been in this next slide. Let me pull this up. Yeah, he ended up acknowledging that he wasn't quite sure how to acknowledge this. He ended up saying, ultimately, Your Honor, I may have to think about that. I've never seen an instance solely like that. And so we're not even talking about a fraud case. It's where somebody develops something and people can choose to use it or not use it. And the SEC seems to be of the opinion that even if you're not promoting something, if there's something that would benefit you if the price goes up, then it still satisfies that requirement of some sort of promotion, in terms of expectation of profit, which I think is absurd. So somebody just expects something of you when you have nothing to do with it, and then because they just choose to have that expectation, now you're on the hook for something from a legal perspective. Well, that's silly, but even outside of that, I don't think that people are expecting that, because the crypto asset class just tends to move in tandem anyway. So there's a lot of holes in the SEC's theory here, but they're just saying what they're saying because they're complete and utter asshats. And then LBRY thread continues. LBRY points out a quote, "LBRY is not a joke coin. It has utility." That's a quote from attorney Mark Jones, a senior prosecuting SEC attorney. And they actually tagged his real Twitter account here, which I found to be comical. So given that he's only got 49 followers and there's 201 hearts on this to this point, I'm sure he noticed because that would pop up in his notifications. So yes. But this literally is that he literally said at that hearing in July, this is the SEC attorney referencing the LBRY coin, "It's not a joke coin. It does have some utility, but they created it." But somebody created a thing. Oh my gosh. Well, then they must be responsible for everything having to do with it forever. That's completely absurd. And then the LBRY continues. "The SEC argues unequivocally that a blockchain token having consumptive utility, is not irrelevant." And I'll also note here through context, I gathered pretty quickly that they meant to write the word relevant. So let me read it while changing that word. LBRY said, "The SEC argues unequivocally that a blockchain token having a consumptive utility is not relevant." Excuse me, folks. All that the SEC believes matters is that the number can go up and down. Literally, that's it. That's why the previous hypothetical is so hard for them too. Exactly. So if the price of something goes up or down, that's it. That's what matters to them, not the rest. And that's why you can see here the judge says, do you concede that there is what I think LBRY is calling a consumptive use for LBC, the library credit token? Mr. Jones, SEC attorney, says, we do, Your Honor. So there you go. It's in the transcript. That actually happened. The SEC acknowledges, yes, there's utility. Now, they deny it in the Ripple case, but here they're acknowledging it, and it still doesn't matter. That's why it's just like common. It just goes back to that argument that we've been talking about a lot in the community lately. It's like common interest is not common enterprise, and that matters supremely from a legal perspective. Then LBRY continues, and they're right. This passage, more than any other, captures the essence of Judge Barbadoro's thinking. LBRY is a mixed motive case with both investment and consumptive purchasing that doesn't match with existing case law. And I'll pull up full screen here and I'll cover it, but I just want to note here, like, or actually, let me just ask you, do you think that there's, in terms of the questions being asked, tremendous overlap between the LBRY case and the Ripple case? Because I sure as hell do. I think there's tremendous overlap, which is why this is so interesting. And especially since, again, it's going to be settled first and it's going to impact the Ripple case to some degree, because you know that Ripple, we'll see who wins. But, you know, if, like, say LBRY wins here, then Ripple will file something. But if LBRY loses here, then the SEC is going to file something in the Ripple case recognizing this. Hey, it's some sort of precedent, even if it's not binding. So here's what the judge said here. But then you still have to ask, in a mixed motive case, if some acquirers are acquiring for purely consumptive and others are acquiring purely for investment. What is the test by which a judge evaluates that kind of a case, which I don't think any of the cases I've seen have really evaluated in detail? That kind of problem, and that's what we seem to have here. So let's pause and note again. I appreciate that he wants to stick by precedent. There's not case law covering something like this. Isn't that alarming? Yes. Yes, it is. Because if you're going to try and shoehorn this into something that exists, you're going to have a problem, don't you think? That's why I said, like, I'm optimistic, like, in terms of the tone that the judge has here. But if he's going to stick to this thing where he must apply to existing case law and not create new precedent, well, maybe he finds a way to get through that and it's not going to be messy. I don't know, though. That's why I said, like, I'm cautiously optimistic, but I'm not completely optimistic, because he's acknowledging there's not case law, but, like, what do you do about that then? You can't just make there be existing case law that you can copy. That it doesn't work like that. And then he says, I think it's undeniable that people are acquiring LBRY credit tokens for investment reasons. I think it's undeniable that people are acquiring LBRY credit tokens for consumptive reasons. How do I determine in a case like that whether something is acquired? A reasonable investor, considering the total mix and not looking at any one factor, determine where some investors are acquiring for consumptive and some investors are acquiring for investment. How do I determine whether in that case it meets the first component of the third element of the Howey test? So there you go. The judge is saying, I don't know how to do this. And you know what, that's fine, because sometimes when you're, to some degree it's fine, because a lot of times in life when you're posed with a question, you don't know the answer and you have to think about it and you have to do research. So that in and of itself doesn't mean that we're going to experience a travesty, but I just want to make sure that we're all aware of this. This is the judge acknowledging, I don't know what to do here. Plain as day. So hopefully he figures it out and we have a good application of the law here. But this is why, again, I say, I'm cautiously optimistic. You see what I'm saying here? And then there's this, LBRY continues. The judge asks if there's anything LBRY could do to avoid being a security. The SEC, of course, refuses to answer. And here's the screen grab from the transcript here. And he reads as follows. So the judge says, is there in the SEC's mind a way in which LBRY could operate the LBRY blockchain using LBC as a digital asset that would not qualify LBC as a digital asset as a security? And Mr. Jones, the SEC attorney, says, Your Honor, I want to be very careful for this answer. The court says, again, that means the judge, I understand. Mr. Jones, I am not a commissioner appointed by the Senate. I am not a policymaker. I am a lowly trial attorney, enforcement attorney who's in charge of enforcing the law as it stands now. Yeah, except for you're making assertions that aren't in line with the law, Mr. Asshat Attorney. That's the problem. I know you're not in charge of policy right here, But my gosh, you have to know that this S word doesn't apply. I caught myself there. But of course they don't have an answer. You know, it's just, what is the path forward? The SEC, I don't know. Well, that's because they don't know what the hell they're doing here. There is no path forward. They just want to sue everyone into oblivion. And then LBRY wraps up by stating, rereading this transcript, overall the judge seemed skeptical of many SEC positions and favorable to ours. SEC overplayed their hand multiple times, while LBRY basically never did. Now we return to waiting. The best is yet to come. And so that's where we're at right now. LBRY, optimistic. So that's good. And I'm more on the optimistic side too. And I want this to turn out well for LBRY. This is going to have an impact on the entire crypto space here. But I don't know how long this is going to take. Like, everybody was anticipating that there was going to be some sort of ruling by now, but there isn't. And again, like I said a couple times already, I'm actually okay with that. I'd rather the judge miss his own self-imposed deadline, which was kind of meaningless anyway. It was just him being overconfident about how quickly he could choose. I'd rather have that than him just kind of push through something where he's like, I don't know, let's just get rid of this. I think he recognized the gravity of this. And I wouldn't be surprised at all if he's reading all the amicus briefs and the SEC v. Ripple case. In fact, I expect that he is, because he seems like a sharp dude, and I think he wants to be well-informed in making this highly consequential decision. I wouldn't be surprised in the least, because there's not sufficient case law. So even if he wouldn't necessarily normally go to that, separate case, even if, well, for something like this, where he's acknowledging there's not case law in place to help make a sufficient determination, well, if I were him, I sure as hell would, and I bet that he is. He has to be well aware of the fact that the SEC is suing all sorts of crypto-related companies into oblivion. Still optimistic, though. Let me know what you think below. I'm done. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.